Welcome to the Assembly Committee on Government Affairs, the early rising and hardest working committee in the Nevada State Legislature. I think we might be the first committee that started today, at least in the Assembly. So, well, the Senate got to leave early, so we were here till about midnight. Will the Secretary please call the roll?
Assemblyman Carter. Present. Assemblyman DeLong. Present. Assemblyman De Silva. Here. Assemblywoman Duran. Here. Assemblywoman Gonzalez. Here. Assemblyman Gurr. Here. Assemblyman Hibbets. Assemblyman Koenig. Here. Assemblyman MacArthur. Here. Assemblyman Wynn. Assemblywoman Taylor. Present. Assemblywoman Thomas. Here. Chair Torres.
Welcome to the audience here in Carson City, those joining us in a full room in Las Vegas, and those listening over the internet. Just a couple housekeeping items. As a reminder, please remember to silence your electronic devices. If you wish to testify, please sign in at the table by the door and provide a business card to the committee secretary. For those joining online, please be sure to mute your microphone when you're not speaking to minimize background noise. When testifying, please turn on the microphone and clearly state your name and affiliation, if any, for the record. Then turn the microphone off each time you are done speaking. Handouts should have already been provided to the committee staff. We expect courtesy and respect in our interactions during the meeting, even if we do not agree with another person's position. Committee members will be using their laptops to view handouts and other documents. Please do not view this as a sign of disrespect or inattention. Public comment will be taken at the end of the meeting. Each person will be limited to 2 minutes. In addition, the public may submit written testimony to the committee up to 24 hours after the hearing. Just a couple notes for the committee. We do have 4 bills today. We will be hearing them out of order. I believe 2 of them belong to are Senator Neal's bills and 2 of them are Senator Harris's bills. So we will be hearing Senator Harris's bills first. If we are pushing up against floor, I will roll or push bills back, and we will have to schedule those for a different time. So today we are going to go ahead and start with SB 225. So we will open the hearing on SB 225, which revises provisions governing peace officers. When you're ready, you may begin.
Good morning, Chair Torres.
Just one moment real quickly, too. And I know that Assemblyman Wynn is out. We can just mark him absent, excused, and present when he arrives. Thank you.
Good morning, Chair Torres, members of the Assembly Government Affairs Committee. My name is Dallas Harris. I represent Senate District 11. Thank you all so much for hearing Senate Bill 225 this morning. To my right is my esteemed colleague, Assemblywoman Chandra Summers Armstrong. And before we get started, Madam Chair, I'd just like to state on the record that I'd like to submit an amendment to add Ms. Summers Armstrong as a co-sponsor to this bill. This is something that she and I have been working on ever since we participated in the NCSL Legislative Police Academy. In its most simple form, this bill ensures that if you have been decertified in another state, or even in this state, or if you have resigned in order to avoid being decertified, you will not be a police officer here in the state of Nevada. We have seen time and time again where officers who exhibit what are sometimes really unprofessional behavior can simply pick up and move and go get a job as a police officer down the street in another state. We're going to make sure that doesn't happen here in Nevada. I'm going to turn it over to my co-presenter for a few words, and then we will be happy to answer any questions about the bill.
Thank you, Madam Chair, and thank you, Senator Harris, for inviting me to sit with you this morning. For the record, my name is Chandra Summers Armstrong, and I represent Nevada Assembly District 6. I am uncaffeinated, so please bear with me. Last year, we went to this conference in Colorado about policing. It was extremely insightful. For those who don't have a lot of history in policing like myself, it was a really good opportunity to learn from people who are in the business, and also to learn from other states how they conduct business. And I sat at a table with a lovely gentleman from Arkansas, which is where many of my family members are from. And we got to talking about, in conversation about police behavior and about recruitment and about just how people move about. And one of the things we found so interesting is that they already have laws in place that prohibit anyone who has been fired for misconduct, who is retiring to avoid firing or resigning to avoid firing, from being certified. And so Dallas and Senator Harris and I began to talk about this in the interim and thought that this would be an interesting piece of legislation to bring to our state. We know that we are an attractive place for people to come to live because of our tax structure, because of our beautiful weather, and just because Nevada, she is a beautiful place to live. But we also want to ensure that the folks who come here are the folks that we want to be policing our communities. And we hope that you will consider this legislation favorably and have any questions. We're here to answer. Thanks.
Members, any questions? I'm going to go ahead and start with Assemblywoman Gonzalez, and then I'll go to Assemblywoman Taylor.
Good morning, Senator, and thank you so much for the presentation. So I was curious, if folks are coming from another state, how would we get that information? In the example in which you stated like they would resign before getting this designation, then how would we get that information? Thank you.
Thank you for the question, Assemblywoman Gonzalez, to you through the chair. Dallas Harris for the record. So there are two ways. One, if you are decertified and you are in a state that participates in the National Decertification Index, Post will be checking that National Decertification Index for every person who comes in. Now that decertification index is voluntary, which means there are some jurisdictions that do not participate. And so on the back end, in case we do not catch that, when you want to become Post certified, this bill will require you to fill out an affidavit that says you have not been decertified in another state and that you have not resigned in lieu of decertification. And if you falsify that affidavit, that is also a reason for your certification to be revoked.
Assemblywoman Taylor.
Thank you, Chair, and good morning, Senator and Assemblywoman. We can get you some coffee if you need it. Just, you know, we got people in here, so we can get you coffee. But thank you for being here, and thank you for bringing this bill. Really, really important. I'm sure all of us became more aware of this as an issue as we saw, you know, incidents happen across our country. Here's my question: is I know it's if you've been decertified or retired or resigned in lieu of, how does decertification work? If I've had misconduct as an officer or something in whatever state, how does that work and they get decertified?
Thank you for the question, Assemblywoman Taylor. To you through Chair Torres. Dallas Harris for the record.
Please just go directly to the member.
I will. Thank you so much. Much like a licensure, you have a license. If you mess around, that board that certified you will revoke that license. And so when you go and get a job and they say, are you certified? You would no longer be able to say yes. So yes, in our state, it is Post, the Peace Officers Standards and Training Division that has to offer that certification. And without that, no local law enforcement agency can allow you to be a police officer. So it would work very similar to if you're a cosmetologist and you lose your board certification, you wouldn't be able to work in any salon in the state.
Okay, thank you, Senator. May I
Absolutely.
follow up quickly, Chair? Okay, thank you. Thank you, Senator, for that answer. And I'm going to go a little further then. So if someone they'll be able to tell in their departments because they're following what's going on. What if someone resigned and then so they didn't get, how will they find out?
Thank you for that question, Assemblywoman Taylor. Dallas Harris for the record. So there are two pieces in this bill that would happen when someone is in state. First, if an investigation is initiated, there will be a notification to Post. Post will know, hey, this officer is under investigation for certain misconduct. If they resign, the law enforcement agency is, under this bill, required to submit a final adjudication to Post of that investigation. And so the officer they may resign, but the investigation continues. And once that investigation is complete, Post will be notified of the results of that investigation.
In another state?
If
Oh, I'm sorry. Okay, thank you. I'm
Dallas Harris, for the record. If you're in another state, Post is not going to be notified. However, if you resign in lieu, you're going to have to come here and write out an affidavit as part of your application that you have never resigned in lieu or are not on the decertification index already.
Thank you very much. Thank you, Madam Chair.
Thank you. And before we continue on this conversation, I know I have a couple members that have a couple other questions, but I was wondering if you could give us a little bit more information about the decertification complex. And I'll just very quickly express the only concern I have, because I definitely agree that, if you've been let go, if you have resigned because of some incident, if you have been disciplined because of misconduct, right, that we shouldn't be inviting you onto force. But then I do see that there might be a group of individuals that are unfairly targeted, and oftentimes when we hear about these situations, they're officers of color that are in an environment that is not conducive to a positive work environment, and then they end up being let go or being accused of something that others are doing. And that's the only gap that I have. So I'm wondering if you could talk about that decertification process and what that looks like, because I want to make sure that that process is still just.
Yeah, thank you for that question, Assemblywoman Torres. Dallas Harris, for the record. So first, let's separate being fired and being decertified. The two don't always come together. A law enforcement agency may choose to release you, but that doesn't mean that you have reached the level of losing your certification in any given state. So when we're talking about policies and procedures, violating those, being tardy to work on multiple days, those are generally not acts that will result in a decertification. Now, I can't guarantee you what the laws are in every state about what results in decertification, but they are generally the more egregious types of acts where a state's going to say, we're going to take away your certification to be a peace officer. And so, the goal here is to not target folks who may lose their job for the plethora of reasons that people may be let go in a employee-employer relationship, right? But to ensure that we're not allowing the worst of the worst. And then I'll also note that police unions in this country are fairly strong, and so if you lose your certification after all of your rights have been enforced through your union, chances are it's not something small. And I had this conversation with Post. I will be honest with you all, when I first approached Post, I said, hey, listen, can y'all give me a list of reasons why someone would be decertified and we may not want them here? And Post responded to me, if they've been decertified at all, we don't want them. And essentially, the reasoning behind that is, listen, if you can't follow the rules in another state, even if they're slightly different than the rules in our state, why would we feel comfortable that you're going to come here and follow our rules? And so that's where we've landed on this piece of legislation, Madam Chair.
Thank you, and I appreciate that context. Assemblyman Thomas.
Good morning, and thank you, Madam Chair. And thank you, Senator and Assemblywoman, for bringing this piece of legislation before us this morning. My question, actually, there's more to this bill. I'm looking at the cannabis portion of the bill that we have not discussed, and I was just wondering if you could give some additional information on that.
Thank you for the question, Assemblywoman Thomas. Dallas Harris, for the record. So I don't know what section it is because I don't have the bill before me. But what it says essentially is that once you've decided to be a peace officer, you probably shouldn't be using marijuana. Right? We aren't going to allow officers to use marijuana as they carry out their duties. If you're employed as a law enforcement agency, you are not supposed to be using. But we need to put a reasonable limitation on that, right? If you were smoking up 5 years ago when you were in high school, I don't necessarily see that as some tie to how good of a police officer you're going to be, especially if you were of age in a state where it is legal to do so. But it is very important that especially when we're looking for determining what kind of judgment a person has. I think it's completely and utterly reasonable to say, well, since you decided to become a cop, since you put in an application, have you been using? And that's what this bill would do.
Thank you for that explanation. Now, would that be a cause of decertification?
Thank you for the question, Assemblywoman Thomas. So if you were using while employed, is that your question? Ooh, that is actually a very good question, Dallas Harris, for the record. I'd have to ask Post. I don't know if that is on the list of reasons for decertification or if there are other steps and disciplines that would be put into place, but Post would be probably best suited to answer that.
Thank you. And just to build off of that question regarding cannabis, are there instances right now where officers are being disqualified from being able to be eligible to be an officer because they have used cannabis before they became an officer?
Thank you, Madam Chair, for the question. And that is actually the reason why this is here. It is actually a disqualifier. And we know that it is legal in our state. And that it is acceptable under the laws that we've put in place. And so we don't want that to be something that's going to exclude people who can bring cultural competency and equity and diversity into the force just because they've used when it's legal and they were adults to do so. So we want our police forces to represent our communities. But we also know that once you have decided to be an officer, now it is time for you to comply with the culture of policing in our state and then not partake any longer. Thank you.
Thank you, Assemblywoman. Thank you, Assemblywoman. I think that helps clarify it too. So it's to prevent something that's already being done. It's just to make sure that those policies only occur for while you're actually doing the job, because you might not know at 15, at 21, at 22 that's the career that you're going to want eventually. Assemblywoman Gonzalez. Vice Chair Duran.
Thank you. And I'm just reading under Section 4, number 7. Screening test means the test of a person's blood, urine, and hair or saliva to detect the general presence of a controlled substance. But in our contract, and according to our attorneys, the best determination is your blood, because urine doesn't go to your brain. So why would you have the rest of those tests to be sure, because blood is the accurate testing?
Thank you for that question, Assemblywoman Duran. Dallas Harris for the record. So marijuana may not be the only thing that they're testing for, right? But we wanted to ensure that law enforcement agencies, as they are hiring folks, can drug test them, right? If that's the issue, you want to make sure they're not using any type of illicit drugs. We're not going to prohibit you from putting them through a drug test as a method of employment, as long as you drug test everybody, right? If that's the policy that you want to take and you don't want to take anybody's word for it, you can do that. You are correct that blood is best for certain things, especially when it comes to things like cannabis use. But urine tests can also be useful for other substances as well.
Your blood does contain all those. That's just the most accurate, because there is different GMCS testing, I believe, the results. It just may take a little longer.
Absolutely, Assemblywoman Duran. Dallas Harris for the record. I'm not going to disagree with the science. And my inclination is that the Legislative Council Bureau of Legal probably took this from another place where we already have a definition of what drug testing is and simply applied it here.
Thank you. Assemblywoman Gonzalez.
Thank you so much. So this conversation just sparked a question for me. I thought we were one of the first states where we enacted that you can no longer test for pre-screening for marijuana. So I'm just curious how that would work in this situation. Thank you.
Thank you for the question, Assemblywoman Gonzalez. Dallas Harris for the record. You are correct, except we've exempted certain industries, and law enforcement agencies would be one. There are commercial, people who drive commercial trucks, right? CDLs is another. There are some areas that we exempted from that, and for certain reasons.
Thank you. I appreciate that. I think that was definitely before my time.
Members, any additional questions? Assemblyman Hibbets.
Thank you, Chair, and thank both of you for being here. My question is, during your, going back to the decertification portion of the bill, during your conversations with Post, did you ask or were they able to provide any numbers on the amount of peace officers that are decertified on an annual basis in our state? Because obviously we're not going to have it from other states. I'm just curious.
Thank you for the question, Assemblyman Hibbets. Dallas Harris for the record. No, I did not get those numbers. I can definitely make sure I follow up with you on that, though.
That would be wonderful. Thank you very much. Thank you, Chair.
Members, any additional questions? Assemblyman Carter.
Does our state participate and actively participate in the National Decertification Index? I see it's referenced in the bottom of the bill, but it also appears that there's problems with not every state fully cooperating and complying with that database.
Thank you for the question, Assemblyman Carter. Dallas Harris for the record. I believe Post does currently participate, but of their own volition. If we pass this piece of legislation, they will in fact be required to.
Members, any additional questions? And while the hardest working body in the Nevada State Legislature was here until well into the evening, they had tons of questions, but we were finally done. So at this time, we will go ahead and move on to support. So at this time, I'll invite anyone wishing to testify in support of SB 225. When you're ready, please begin.
Good morning. My name is Aisha Goins, Aesha Goins. I'm here on behalf of the NAACP of Las Vegas, Nevada, and we just want to say we support this bill. Thank you.
Thank you. I don't see anyone else here in Carson City to testify in support. Is there anyone in Las Vegas? I don't believe there is. BPS, is there anyone on the line wishing to testify in support of SB 225?
Chair, there are no callers choosing to testify at this time.
Thank you. We'll move on to opposition. Is there anyone wishing to testify in opposition to SB 225? I don't see any here in Carson. I don't see any in Las Vegas. BPS, is there anyone on the line wishing to testify in opposition to SB 225?
Chair, there are no callers choosing to testify at this time.
Thank you. At this time, we'll go ahead and move into neutral. Anyone wishing to testify in neutral to SB 225? When you're ready, you may begin.
Morning, Madam Chair, members of the committee and staff. Rick McCann, Nevada Association of Public Safety Officers and a member of the Nevada Law Enforcement Coalition. On a personal level, I really do not like neutral, but I want to be heard on this thing. We need to police our own. There is no one who hates a bad cop more than a good cop. We absolutely give a tremendous amount of respect for Senator Harris and all the work she's put into this thing. It's gone through a lot of iterations. She's had input from Metro and a lot of other groups. We respect that tremendously. We had to be heard on this to show neutral position, but quite frankly, we're supportive of anything that helps us police our own because that's where we're at in this life. We need to do that. Cops need to take care of themselves. They also need to police themselves. So we are a neutral, but a positive neutral. Thank you.
Good morning, Chair Torres, members of the committee. My name is John Abel, Government Affairs Director for the LVPPA, and we are neutral. I want to thank Senator Harris for amending this bill for us in the very beginning. That's why I'm in neutral. But also here to answer questions as well, if you have any, about the decertification process and how Metro handles their hiring and firing. Obviously, I'm well versed in that, as I'm one of their union reps. And I will also tell you that Metro's stance on marijuana is changing. I had someone who was permanently DQ'd a couple of years ago who approached me and asked me to help him because he still wanted to be a police officer, and he was DQ'd for marijuana. And because I helped him and had his disqualification reviewed, he starts the academy in August. So if, with that, I'm neutral. If you have any questions, please ask.
Thank you. I think the question that we had, and I think the senator here started to get there in answering, but you might have some more context, is what incidents might an individual be decertified for? What kind of incidents are we looking at?
Well, obviously, truthfulness is a very big issue, right, for police officers. So truthfulness, committing a felony crime, some misdemeanor crimes, domestic violence, things like that.
Thank you. And I think Vice Chair Duran has a follow-up.
Sure.
Thank you, and I know people deserve a second chance. So is there, based on, I think you just said it, based on their honesty and stuff like that, what other types of conduct would help them reinstate their certification? If there's any.
I'm not quite sure I understand the question. I know, obviously we have a discipline process. So if they can go into internal affairs and if they're accused of truthfulness and they can prove that they were not untruthful, if they have witnesses that they weren't untruthful, if body camera video exonerates them. But I don't believe we have anybody. So for Metro's hiring process, when someone selects to hire with LVMPD, they have to fill out an affidavit that allows LVMPD to get their entire discipline file from their other agency. And if there's any kind of discipline proceedings, Metro typically does not hire them. And if they refuse to fill out the affidavit, then they won't be hired by us. Hope I answered your question. I'm not sure if I did.
No, my question, well, I guess it kind of does, but like I'm saying, once a person loses their decertification, and based on you said, is there any chance they can get it back other than being truthful or their certification?
I don't think so because once you're untruthful, you're untrustworthy to LVMPD. So.
And so truthfulness is one of the items that would decertify an officer?
I believe so, because Metro will actually terminate you if you're untruthful.
Thank you. And what is what does that process look like? And I apologize for putting you on the
it's
stand.
okay.
We just
Absolutely.
be very clear too. We're asking questions because we know that you're one of the experts that we have
Yep.
in the room. And so, what does that process look like? I mean, you can be accused of not being truthful. I guess I don't know enough about this system to have confidence that this is a fair and just process that allows for individuals to fully partake in that. So if you could give a little bit of context of what that looks like.
So if you're accused of truthfulness, typically internal affairs investigation proceeds, and they call you in for an interview, and they give you your Garrity protections, and then they present the evidence that they have, the department, that you were untruthful. So they could have witness testimony or witness statements. They could have body-worn camera. I know a lot of times body-worn camera is used. And then the officer is asked questions as to why they were untruthful. And if they don't provide a good enough answer as to why they were untruthful, then Metro will terminate you. It happens all the time. And so once you were untruthful and Metro terminates you, I don't believe you can be a law enforcement officer anywhere else in the state.
Thank you. I appreciate that.
Yeah.
And I'm happy to continue these conversations offline. I guess my concern would be if that they're, and I don't say this of our Nevada police, but in other states, if there are police forces that are taking advantage of certain officers in certain positions, I could see instances where officers would be let go and accused of untruthfulness, but it could be a false accusation. If those processes are completely internal, there is no other process for that.
In the over 5 years, almost 6 years, I've been with the police union as a rep. I've never seen it because we fight pretty staunchly for our officers, and if we think that they're targeting an officer, we don't stand for it, and we've actually filed lawsuits before to help them. So it hasn't happened while I've been a union rep, but I can't speak for other agencies.
Thank you. I appreciate that context. Assemblyman Thomas.
Thank you. My question has to do with the National Decertification Index. is that part of the FBI background investigation? Is there not two separate investigations?
That I have no idea about. I don't.
When a prospective employee wants to be a police officer, do you not do an FBI investigation?
So I would assume that yes, LV and PD, and as a part of their background investigation, does do that. But I don't have that information in front of me to 100% confirm that.
Thank you. I do not believe we have any other questions
thank
at this
you.
time. Thank you for your neutral testimony and for letting us badger you with questions. I appreciate it. At this time, I don't see anyone else here in neutral for SB 225 here in Carson City or in Las Vegas. PPS, is there anyone on the line?
Callers, if you would like to testify in neutral for SB 225, please press star 9 now to take your place in the queue. Chair, there are no callers choosing to testify at this time.
Thank you. I appreciate that. I don't believe there's anybody else here in Carson City or in Las Vegas, so I'll go ahead and invite the bill sponsors for closing remarks.
Thank you so much for the time, Chair. So one thing I wanted to just point the committee's attention to is NRS 289.510. That is the statute that empowers the empowers posts to promulgate regulations about what type of conduct results in decertification. And so that's outlined in regulation by post. And again, that'll vary from state to state, but for our state, you're going to want to look at NRS 289.510 and the associated regulations. To Assemblywoman Thomas's question about the National Decertification Index and whether it's maintained by the FBI, it is not. National Decertification Index is actually maintained by what could be described as like a trade association of posts across the country. They aren't all called posts, but you know, the Standards and Training Commission for each state for police officers, they have an association that maintains a website and this decertification index, and so it is separate from the FBI. With that, I just want to thank the committee for their time. I think that this bill is the best way to ensure that if you have risen to the level where your certification is revoked after the due process that we afford law enforcement officers in this state and in this country generally, it's likely that we don't need you here in our state on our streets policing as well. Thank you, Assemblywoman.
Thank you. At this time, we'll close the hearing on SB 225. And we will open the hearing on SB 319, which revises provisions relating to public employees.
All right. Good morning again, Assemblywoman Torres and members of Assembly Government Affairs. My name is Dallas Harris. Happy to be here to kick off Senate Bill 319 here with my good friend, Mr. Rick McCann of NAPSO. Madam Chair, if it's okay with you, I have to return to Finance. Would you mind if Mr. NAPSO carries the weight on this one? Mr. NAPSO, Mr. McCann. Would you mind if Mr. McCann takes the fire for me today?
Yes, that's fine. Just no horsing around while we're in here. Thank you, Senator Harris. And Senator, if you could let Senator Neal know that she'll be after this presentation. So I think still around 10 o'clock. So please get your work session done so we can move our bills and then come back here and finish his presentations. Thank you. All right, Mr. Napso, go ahead when you're ready.
Good morning, Madam Chair, members of the committee and staff. My name is Rick Napso. I'm here representing the Nevada Association of Public Safety Officers, NAPSO, and the Nevada Law Enforcement Coalition. First, I wish to thank Senator Harris for sponsoring this bill, together with many co-sponsors, Senators Spearman, Buck, Dondero Loop, Gokachia, Orenshaw, Pazina, Scheibel, and joint sponsor Assemblyman Urick. So now that I've kissed up enough. Generally speaking, if you take a look at NRS 288.425, it states that for the purposes of having collective bargaining, a state employee, and we're talking about state employee, they are defined as someone who is A, either a classified service employee, or B, is employed in the state system of higher education, NG, in the classified service. NRS 288.515 created bargaining units, as you're aware, back in 2019, for 11 separate occupational groups of employees. One of those 11 bargaining units is Category 2 peace officers. You're all aware of that, I'm sure, by the history of what we've all gone through this session and previous session. There are Category 2 peace officers, however, who are left out of collective bargaining. Those would be gaming control officers, peace officers. They are sworn peace officers. They are Category 2. But why are they left out? Because they are unclassified state employees. So they don't meet the current definition of being in state collective bargaining. Section 1 of SB 319 in front of you merely seeks to add one sentence to the definition of an employee, quote unquote, solely for the purpose of allowing them to collectively bargain. Section 1B, as in boy, is inserted to include Category 1, Category 2, or Category 3 peace officers who are unclassified employees. Pursuant to current law, which is NRS 463.080, sub 4, for those of you wonks who like to write that stuff down, gaming control board employees, with the exception of clerical employees, are unclassified employees. That same statute, 463.080, also requires that the Gaming Control Board establish and modify, as necessary, a comprehensive plan governing employment of its people. That means the board can permit collective bargaining for its peace officers, as we are attempting to do here in SB 319. For the past 4 years, gaming control agents, such as Category 2 peace officers as they are, have been sitting by patiently, while other Category 1, 2, and 3 peace officers have been benefiting from collective bargaining, and they, the gaming control people, have been left out. Now, someone did ask me at one point in time whether putting these folks into, excuse me, the bargaining unit would make them classified employees, make them go from unclassified to classified. That was a great question. I didn't know the answer. So I reached out to gaming, and I was informed by the administrative division that putting them into collective bargaining will not make them classified employees. That can only be accomplished legislatively with changes to NRS 463.080, and that is not the purpose of this bill. So they will remain unclassified within the section of collective bargaining. We believe it's time for Category 1, 2, and 3 unclassified state employees to be permitted to engage in collective bargaining like their peace officer brethren. And for this reason, we ask for you to support SB 319. Thank you.
Thank you. Members, any questions? Assemblyman DeLong.
Thank you, Chair, and thank you, Mr. McCann, for the presentation. A couple of quick questions. One is, are there Category 1 or Category 3 peace officers that are unclassified?
Rick McCann, for the record, thank you for the question, Assemblyman. I am not aware of anybody other than gaming control people who are unclassified in the Category 1, 2, or 3 area. I could stand to be corrected. If LCB knows that, I've been wrong before, once or 100 times this session. But right now, my categorical answer would be no, other than gaming.
So as a follow-up to that, then why are we including 1 and 3 in this? I think we're trying to put in a statute that doesn't cover anyone. You then, at the end of your testimony, said that all unclassified should be covered in a bargaining unit. I'm paraphrasing a bit, but that's not what this bill does. And so are you advocating for something beyond what this bill says?
Rick McCann, for the record, thank you for the question, sir. No, I'm not talking about any unclassified people other than Category 1, 2, and 3. And your previous question, why are we dealing with 1, 2, and 3 if there's no more other than gaming? I think as in an abundance of caution to make sure if there are other Category 1, Category 2, or Category 3 unclassified officers that I'm not familiar with, we would certainly want them to be in this as well. I'm focused on gaming because they're the big people who brought this forward. If there are others out there, I would want them captured as well.
Okay. Thank you very much.
Members, additional questions? Assemblyman Taylor.
Thank you, Chair, and thank you, Mr. McCann, for bringing this forward. Just a quick question, clarification-wise. So really, excuse me, they're already classified as peace officers and get all of the benefits and so on that go along with that. This is really just to classify them because right now they're considered unclassified. It doesn't do anything else in terms of their status.
Rick McCann for the record. Thank you for the question, ma'am. They would not be classified. Again, they're going to remain unclassified, but they will be brought into collective bargaining.
As unclassified.
As unclassified, yes, ma'am.
Thank you
As a
for
matter of fact, the documentation I've received from gaming has made it clear they would remain unclassified, but be unclassified members of the bargaining unit.
Okay, got it.
Thank
you very much. Thank you for the clarification. Thank you, Chair.
Assemblman Hibbets.
Thank you, Chair, and thank you, Mr. McCann, for bringing this, or at least assisting to bring this bill. My question, it's not fully formed in my head, so forgive me. So gaming control officers are Category 2 peace officers. Somebody supervises those people, is that correct?
Rick McCann for the record. Yes, they do.
So are those supervisors considered commissioned Category 2 officers also?
Rick McCann for the record. Yes, I believe they would be, and as a matter of fact, they would now be moving into a group of people who would be under collective bargaining under a separate bill, SB 166 that I brought. It's somewhere else in the building here.
Okay, so currently as it stands, as of today, the Category 2 gaming control officers and their Category 2 supervisors do not have the right to collectively bargain. Is that how I'm seeing this?
Rick McCann for the record. You've seen it perfectly, sir.
Thank you. I appreciate the clarification. I just want to make sure that my less than caffeine-addled brain had figured it out.
I have to say, I really appreciate those those questions because I think that clarified a lot of this piece of legislation for me because I too have not, well, I actually haven't had any coffee this morning and I'm running on very little sleep. But we do have horses, that's right. That gives us a little bit of energy for the day. Members, any additional questions? It doesn't appear there are any. At this time, we'll invite anyone wishing to testify in support to SB 319.
Thank you, Chair Torres, members of the committee. I'm John Abel, Government Affairs Director for the LVPPA. As someone who represents a collective bargaining unit, I know how important these rights are to our members. So for that reason, we support the bill. Thank you.
Chair Torres and committee members, Kent Irvin, ERVIN, as of yesterday, past president of the Nevada Faculty Alliance. 2 more years as past president. We support state employees being able to bargain collectively with their employer, as do local government employers. Our bill, AB 224, which this committee heard and passed quite some time ago, and you'll be seeing very soon, I hope, authorizes collective bargaining for unclassified employees at the Nevada System of Higher Education. But the definition of professional employees in that bill does not overlap with Section 1 of SB 319. It makes sense for Category 2 peace officers who happen to be unclassified employees to negotiate along with their classified Category 2 peace officers. Thank you.
I don't see anybody else here in support for SB 319 here in Carson City. Is there anyone in Las Vegas? I don't believe I see any. BPS, is there anyone on the line?
Callers, if you would like to testify in support of SB 319, please press *9 now to take your place in the queue. One moment, Chair.
Chairwoman Torres, the members of the committee, for the record, Carlos Fernandez, representing the Nevada State AFL-CIO. On behalf of over 150,000 members and more than 120 unions, the Nevada State AFL-CIO proudly supports Senate Bill 319. Thank you. Hello, members of the committee.
Yes, please continue.
Hi, my name is Mike Wynn. I am in fact, a Gaming Control Board enforcement agent.
And I apologize. I'm going to first
ask the state of Nevada. And
sir, if I could first ask you to spell your name, please. Thank you.
It's Michael, common spelling. Last name is going to be H as in Henry, U as in Union, Y as in Yellow, N as in November, H as in Henry.
Thank you. Please carry on with your testimony.
Like I said, I am a Gaming Control Board enforcement agent, and I would like to wholeheartedly put my support towards this bill. It is time for me and my fellow enforcement agents to be part of the collective bargaining. And I don't want this bill to not pass because that would cause a lot of enforcement agents to consider employment elsewhere, and it would actually harm us too in trying to recruit future police officers to want to join our agency. And again, I hope you guys would support this bill. Thank you.
Chair, there are no more callers choosing to testify at this time.
Thank you. At this time, I'll invite anyone wishing to testify in opposition to SB 319. I don't see any here in Carson City or in Las Vegas VPS. Is there anyone on the line wishing to testify in opposition to SB 319?
Callers, if you would like to testify in opposition to SB 319, please press star 9 now to take your place in the queue. Chair, there are no callers choosing to testify at this time.
Thank you. At this time, I'll invite anyone wishing to testify neutral to SB 319. I don't see any here in Carson City. I don't see any in Las Vegas VPS. Is there anyone on the line wishing to testify neutral to SB 319?
Callers, if you would like to testify in neutral for SB 319, please press star 9 now to take your place in the queue. Chair, there are no callers choosing to testify at this time.
Thank you. At this time, I'll invite Mr. Napso for any closing remarks.
Thank you, Madam Chair. Listen, I know what you're thinking. This is probably the most incredible piece of legislation you've seen. I get it. I'm there with you. I feel it. We have no opposition. We're on a roll. I think we should go ahead and work session this little guy and get this puppy out of here, and that way you'll be done with me for the session. Thank you.
Thank you, Mr. Napso. You can get off your high horse. We appreciate it at this time. We'll go ahead and close the hearing on SB 319. 1 minute recess. At this time, the Assembly Committee on Government Affairs will reconvene and we will open our work session. Today, I am not going to consider the first bill just to give my members a little bit more time to review it. I do know that we got it introduced and referred to our committee late last night, so I just want to give everybody a little bit of time to do that before we work session it. But we did have the opportunity to get SB 319 a little bit earlier in the day. So at the time, we'll go ahead and open up that work session on 319, and I'll toss it over to our policy analyst, Ms. Rudy.
Thank you, Chair Torres. This is Jennifer Rudy, Committee Policy Analyst. Senate Bill 319 that you just heard adds persons who are employed as Category 1, 2, or 3 peace officers in the unclassified service of the state to the definition of employee for purposes of collective bargaining. There were no amendments. Thank you.
Members, are there any questions on the bill that we just heard? It doesn't appear there's any additional questions. So at this time, I'll entertain a motion to do pass SB 319. I have the motion from Assemblyman Hibbets, and I have the second from Assemblyman DeLong. Members, are there any questions? Or discussion? It doesn't appear that there's any. All in favor, please say aye. Aye. Any opposed, say nay. This motion does carry. And I'll send that floor statement to Assemblyman MacArthur. Thank you. At this time, we'll go ahead and close the work session. Thank you, Mr. Napso. It was great having you in our committee. We'll go back into a 1 minute recess. And at this time, the Assembly Committee on Government Affairs will reconvene, and we will open the hearing on SB 143, which revises provisions. relating to discrimination in housing. Senator, when you're ready.
All right. Good morning, Assembly Committee on Government Affairs. So SB 143 does several things. So in 2021, HUD performed an internal review of NERC statutes 118 through 233 and came back with comments where they found major and minor concerns related to substantial equivalence and alignment with federal law. So sections 1 through 32 basically allow us to align with federal law, allowing substantial compliance with HUD. Sections 32, 33, and 34 create the fair chance housing provisions related to that I'm creating in statute. So basically, the fair chance housing, we have a specific population that is being asserted in this bill, and it is anyone who has a criminal history, who has been acquitted, granted a pardon, or otherwise exonerated. And those individuals cannot be discriminated against in regards to housing. The bill basically allows an entity to inquire so they can find out what exactly is the background of the individual, and then if they find out that they're subject to they have been acquitted, granted a pardon, otherwise exonerated, or record sealed, then they need to then take a look and then say, you know, these potential individuals may be allowed housing. The piece also has, if you have an arrest record, so if you have an arrest and you have not been convicted, caveat, you have not been convicted, they also fall into the category of not being discriminated against. So fair chance housing, or ban the box, has been instituted in several cities. The idea is to allow individuals who have been released from our system, who are trying to re-enter society, to then have a safe place to live. We also know that if you have to return back to the same environment that created your criminal behavior, you have more likely a chance to recidivate. And so watching the process in Nevada in regards to our re-entry programs, one of the largest barriers has been able to try to find housing that will sustain individuals. There's also a section in here that if you go to Section 35, which deals with the guarantor of an apartment. So when you go and apply for apartment, if you're trying to be a guarantor, if you're, for example, I encountered this during the interim, it's 5 times for the guarantor versus 3 times for the applicant. And so I wanted to align that the proof of that you can pay rent is aligned to the 3 times, right? Because there's a higher standard, and knowing with the extended housing crisis, if you're paying $1,900 a month, right, and then someone has to prove 5 times that amount in order to guarantee that you move into the apartment, you're probably not going to get a guarantor, right? And so I wanted it to be equal, which is 3 times the rent, because ultimately what you're asking them to be responsible for is to pay the rent of the person who they're guaranteeing. So those are the most, that's pretty much the bill, because the rest of the sections just pretty much align with what's going on in HUD law and substantial compliance. And so I'll open myself up for questions.
Thank you. Questions from Mr. DeLong?
Thank you, Vice Chair. Thanks for the presentation. I've got a couple of questions, and just going through the bill, just wanted to make sure I understand a few things. Looking at Section 22, it looks like this bill removes the legislature from authorizing a contract between the commission and HUD, and gives the commission the authority to enter a contract if they want to. Is that my correct interpretation?
Senator Neal, for the record, so it takes shall to may, and this was language that was suggested, meaning that it's now permissive for the commission to enter into a contract. It doesn't eliminate, it says unless the legislature by resolution or other appropriate, but the permissive piece just allows for them to do it, but it doesn't eliminate the legislature, because permissive means that you could or you could not. And so NERC is an agency that is directly under the Department of Rehabilitation. And so any act that they're going to do will have to then run through that agency. And this particular language was suggested by HUD, and so it doesn't eliminate the legislature because we still have direct oversight over this agency.
Just as a follow-up, Vice Chair, Chair, your chair's back. It actually changes it from shall not to may. The commission did not have the authority to do it unless the legislature acted. Now they can do it on their own. If they do that, my understanding is then they're taking over the responsibility that HUD has with regards to enforcing. Is that correct?
So what they're doing, they're becoming an additional agency that HUD will be working with them. So what I understand it to what's going on. So if we get into substantial equivalence with HUD, HUD then comes in and trains NERC. They spend a couple of years training them. They also bring in funds that will allow NERC to get up to speed and add on additional investigators. They then become, just the same way as EEOC is in Los Angeles, they then become an agency in Nevada that can take on housing discrimination issues. It does not eliminate HUD. It still allows individuals to file with HUD or to file with NERC for a housing discrimination piece. The same way in current law, you can choose to file with NERC or you can choose to file with the EEOC in Los Angeles. There is not an elimination.
Yeah, I didn't think there was, but it was just giving the state the authority to implement the federal requirements under HUD. Going to section, I think it's 15, 3, the Attorney General may, if requested, et cetera. My understanding is under federal law, DOJ must file a civil action if there's a complaint. But here, under the state statute, we're looking at just being permissive that the Attorney General may do it. Does that create an inconsistency between federal law and state law?
Thank you for the question, Senator Neal, for the record. I don't believe so. The Attorney General, upon request, reviewing a complaint of an aggrieved person to file who, I don't think that is in conflict. And so when the Attorney General looked at this, and this is their amendment to delete the shall and add the may, nothing in the conversations that I had on the other house indicated that we would be in conflict with the DOJ. So I don't know if Asher wants to chime in on this, but my understanding that if the DOJ has jurisdiction over an issue, they are going to have jurisdiction over an issue. Attorney General gets its statutory powers from our state law, and where they're in conflict, that is where federal law supersedes. And that is just basic, I would say, supremacy clause, jurisdictional.
Thank you, Senator. Thank you, Chair.
Thank you, Assemblyman Thomas.
Good morning, and thank
Actually, I apologize. I was going to go directly to our legal counsel.
I was wondering.
Thank you. I appreciate it. Thank you. Mr. Killian.
Thank you, Madam Chair. Asher Killian, Committee Counsel. So, yes, my understanding of the reason why that's a may rather than a shall is that the trigger for the Attorney General being able to file that action is a request by a complainant or aggrieved person. It doesn't necessarily require that it be a verified or substantiated requests. So I believe the idea is to give the Attorney General discretion there to not be required by law to file a suit that the Attorney General knows to be frivolous. But otherwise, I think the expectation is that the Attorney General will exercise his or her discretion in alignment with federal law, but simply have the power not to file a suit that is either frivolous or could subject the Attorney General or the DAG who handles the suit to professional discipline by the bar if the suit was not something that should have been filed.
Thank you. I think that provided some clarification. Assemblywoman Thomas.
Thank you, Madam Chair, and thank you, Senator, for this presentation. My question actually has to do with Section 32. When you were explaining this, it just popped in my head that you are saying that an aggrieved person, be their criminal history, could be a pedophile, a sex offender, and we should therefore allow them to live in a complex with children and or families. I just want a clarification on that, please.
Thank you for the question. So, Senator Neal, for the record, that is a direct exclusion. It shows up on page 21. It also shows up in reference to the Rural Housing Authority, where it references any existing CFR related to sex offenses, or anywhere where we have NRS. If there is a sexual offense, they are directly excluded from this bill. It doesn't matter if they have been convicted, acquitted, exonerated, they are excluded from this bill.
Can you give us a section where that's into?
So if you turn to page 21 for sub B, lines 5 through 11. So NRS 315.031 is a tenant in public housing that could potentially have had a dangerous offense, 42 USC 13663.
I apologize, Senator. I think that maybe your version of the bill has a different page numbers than ours. Can you give me the section number?
It's still section, it's 34.
Okay.
34
Thank you.
goes on for a really long time.
Our page numbers are different. Thank you.
And it might show up in another section as well, but it is directly eliminated.
Yeah, in my version of the reprint, it's page 25. Members, additional questions? I believe I have Assemblywoman Taylor.
Thank you, Madam Chair, and thank you, Senator. Good morning. Just a quick question. You mentioned that this really puts us in substantial compliance with federal law. Do we find, and maybe did you find in your research or legal, that there are other states that are taking the same step to make sure that we're not an extra barrier, if you will?
Senator Neal, for the record. So there are several other states that are already in substantial compliance. This particular, I would say, push in order to come into substantial compliance, from the research that I've known, we have been trying to get into substantial compliance since 2007. However, there were conversations in 2017, 2019, and 2021 with HUD in regards to trying to move language that would then bring us into alignment and update our statutes, which would be similar to what HUD law is saying in regards to familial status and other categories that are in their under federal law that were not in our state statutes.
And this should fix that?
Yes, sections 1 through 32 will fix that.
Thank you, Senator. Thank you, Chair.
Thank you. Assemblywoman Gonzalez.
Thank you so much. Good morning, Senator. So one of my questions about the ban the box policy is, and I'm just curious if this is like a correct example or not. Let's say I'm applying for housing and I have possibly multiple convictions, but they're outside of the scope of what you're saying I could be, like the sex offense, for example. How would we know, or how it doesn't, they don't have one of those charges, but they're still discriminated against anyway? I don't know if I'm asking my. No. Okay, so like, let's say I've charged for like burglary. I have, I don't know, grand larceny, right? And that's not one of those crimes that would fall into being discriminate. Like what this law is saying, what Ban the Box is saying, that you cannot discriminate because I have those charges, right? But they can still deny the applicant, right? So how would this policy help in a situation like that?
So I need to be really clear. So this bill has been amended, and if you have a burglary charge and you have not been exonerated, you have not been pardoned, you have not been told that you are been totally freed, and meaning served your time, that person is in. There is going to be some reconciling that. So, and they can inquire into the conduct, because how else are you going to know, right? So a person puts in an application, then there's going to be an inquiry into their criminal background. And then if it comes back that they have been exonerated, pardoned, right? These are individuals that we have decided have been rehabilitated and therefore free and able to re-enter society. Those groups are in. Anyone else is out.
So in that follow-up, Chair, if I may. So in that situation, okay, so like, let's say I have a burglary charge. I've done my time. I'm now applying for housing, and they run the criminal background check, right? And I get denied. But because we don't have laws that mandate why they deny us, right? I don't know why I'm denied, right? So how could I, or how would I know?
You're going to know, because you're going to be able to trigger a process if you believe that you are discriminated against, which is spelled out it's still in Section 34, but it's sub 3, where it allows the applicant, if they believe that there was a denial, to allow an appeal or a review by the commission if they believe that they were denied on the basis of an unlawful discriminatory practice.
And that would be where they would file with NERC.
That is correct.
Okay, thank you so much.
Thank you. And I have a couple questions, and I might ask a couple more as we go through. I'm sure that there's a couple other members with questions. And obviously we did just get this bill, so I have not had the time to look through this and look as intensely as I would like to, and I'll be looking through it again later. So my question, kind of building off of that, I guess my question is like whether or not there is, like, right now, when you are renting an apartment, is there anything that requires that? Like, do we even know? Like, or do you just do the application? How do you know what you're not getting the apartment for, and how would that be proved?
So thank you for the question. So I had this bill in 21. I did stakeholder groups. I met with women who were in reentry. I met with men who were in reentry. We had total conversations with the apartment association. I chose not to bring or upload that Zoom where you would have had the privilege of watching that conversation. Basically, we found out that they do know on the back end exactly why they did a denial. Now, whether or not they make that public to, they can make it public to NERC, but they do know. And I also have direct and personal experience with a constituent who was denied for a solicitation charge. And so the only way that that came up, it was because it was in their denial. And I saw the letter.
Thank you. I think that clarification helps. And so the NERC would be able to investigate those, and they have the tools, and they would be able to get the information that they need to cause that investigation. And hopefully, I imagine that this would just prevent it from happening. Is that correct?
The idea is to allow individuals to have a chance to live in an apartment or where they feel that they can be safe and not have to recidivate. Yes, it does allow for them to file with NERC if they believe that they're an aggrieved party. NERC has some confidentiality provisions where they're allowed to go and seek information. They're also allowed to negotiate, and so when you see the words in there around conciliation, that is their ability to go in and do a settlement with whoever the complainant or the aggrieved party or the party on the other side, and then also do an investigation. So if you look in sections, I believe it's 14, it lays out pretty much the investigative process. It also lays out their ability to negotiate, their ability to reject an agreement. It also lays out their ability to elect to determine if the matter is something that is well out of their purview and to kick it into court. And then if you go to it continues on section 14, where then it allows a remedy. So in these cases, it would allow a remedy to either cease and desist the unlawful practice, issue an injunction, or do equitable relief, award actual damages to the complainant that they can impose. And then it gives the ramp up of the penalties. And then in section 15, it then allows that if the administrator believes that there's probable cause or not probable cause, to then go ahead and continue to determine whether or not there's a practice in housing that needs to once again kick it into court or kick it to the AG.
Thank you. Members, are there any additional questions? I don't believe that there are any at this time. Thank you. At this time, we'll go ahead and invite anyone wishing to testify in support to SB 143. I don't see any here in Carson City. Is there anyone wishing to testify in Las Vegas? I don't see any BPS. Is there anyone on the line wishing to testify in support of SB 143?
Callers, if you would like to testify in support of SB 143, please press star 9 now to take your place in the queue. One moment, Chair.
Good morning, Chair and members of the committee. My name is Catherine Nielsen, the Executive Director of Nevada Governor's Council on Developmental Disabilities. Across the nation, people with developmental disabilities face a severe crisis in the availability of decent, safe, affordable, and accessible housing free from discrimination. Nevada continues to promote inclusion for people with developmental disabilities to live in their communities and guard against return to congregate facilities or other institutions. We support this measure and applaud the Senator's hard work. We've also submitted some policy recommendations to consider in the exhibit. Thank you.
Chair, there are no more callers choosing to testify at this time.
Thank you. At this time, I'll invite anyone wishing to testify in opposition to SB 143. I don't see any here in Carson City. Is there anyone in Las Vegas? BPS, is there anyone on the line wishing to testify in opposition to SB 143?
Callers, if you would like to testify in opposition to SB 143, please press star 9 now to take your place in the queue. Chair, there are no callers choosing to testify at this time.
Thank you. At this time, we'll go ahead and go to neutral. Is there anyone here in neutral to SB 143? I don't see any here in Carson City. Is there anyone in Las Vegas? BPS, is there anyone on the line?
Callers, if you would like to testify in neutral for SB 143, please press star 9 now to take your place in the queue. One moment, Chair.
Good morning, Madam Chair, Perfect Torres. This is Dora Martinez. I'm so sorry. May I please proceed? I am in support.
Okay, go ahead.
Thank you, Madam Chair. So thank you so much to you and your hardworking committee, and thank you to the sponsor of this common sense bill. We please urge you to pass it. Thank you. Have a good day.
Chair, there are no more callers choosing to testify at this time.
Thank you. At this time, I'll invite the bill sponsor for any closing remarks. It doesn't appear there's any, so we will close the hearing on SB 143. And at this time, we'll go ahead and open the hearing on SB 246, which revises provisions relating to governmental administration.
All right, good morning. Senator Neal here to present SB 246. So SB 246 has two parts. The first section, it creates or places into the charter of City of Las Vegas and North Las Vegas the creation of a workforce program, which they will testify that they already have one. But the key piece of this was prioritizing outreach into neighborhoods that have historically high poverty, and then making sure that they are not prioritizing one group over another. We know historically in poor communities, we all share neighborhoods. I placed this in as an issue that I wanted to take up because it has been a longstanding issue that we have poor neighborhoods that are not necessarily focused on or targeted within communities. They also share poverty goes across all groups and is not indicative of any particular race. It then says that that they must at least on a quarterly basis give an update to the council. It then also includes that they would place this information on a public utility because we know that everyone gets a water bill in order to indicate the workforce opportunities. There was a lot of development that happens, and regular communities don't necessarily know that these are workforce opportunities that are actually going on in the city. And it's not, because I live in the world where real people who work don't go to the city council meetings or pay attention, or maybe not even in the email list. And so that's why I put it on there. The other piece of the city council shall provide a written report to the director of the Department of Training and Rehabilitation is because currently Dieter is already collecting data on workforce by demographics, and they can also break it down by zip code. And that came from my legislation, AB 354 in 2017. So I wanted to be able to add to that particular data piece or data point that they produce to make it more robust so we can understand what is going on in those communities. Then Section 3.11 continues on with the targets around workforce. And then the second part of the bill brings forth only one particular provision related to the charter committee. So you guys had this in your committee. However, the only thing that this is doing is allowing the charter committee to meet. It basically says that they will meet quarterly rather than once every 2 years. It allows for the agenda to be set and that the city council requests not more than 4 items to be considered over that biennium before the legislative session. It also then protects the charter committee from any kind of abuse. And then it then gives some prevents the city clerk from violating any abuse of public trust or authority. And then that pretty much, in essence, is the bill.
Thank you, members. At this time, I'll go ahead and open it up for any questions. So I know I'm going to have a couple. So I see Assemblyman DeLong. I see Assemblyman De Silva. I see Assemblyman Koenig, Nguyen, and Thomas. Okay. Perfect. So we're going to go ahead and start with Assemblyman DeLong.
Thank you, Chair. I appreciate the presentation again. Thank you. I know we had heard a bill earlier this session that had the legislature trying to change the charter of a city without the charter committee weighing in on it fully. And And there was a lot of public comment about the fact that the legislature was trying to do that without getting sufficient local input. Are we going down the same road here?
No. And the reason why we're not going down the same road is because the charter committee is already allowed to meet. What we're doing is making sure that they do meet, and that was in the opposition that was presented in this committee. It was also presented in the governor's statement on why he would veto it, because he wanted to make sure that issues went through the charter committee, and this allows for issues to be presented to the charter committee. The only thing that's happening is allowing for the charter committee to have some form of independence and be protected so that they can meet. And I'm very familiar, the bill was SB 184. It doesn't have any of those other provisions from that bill except for allowing the charter committee to actually meet, so that they can bring, items can be brought to them from the city council in order to review, to then bring legislation or proposed ideas back to the legislature. That's what this does. It does not do any of those things. So in 184, she was eliminating and she was mandating that the legislature dictate. That's not what's happening. I want the charter committee to meet. And the charter committee would be allowed to meet. But I think some of the testimony that came up and also some of the questions was that why wouldn't we allow charter committees to do their work, which is the citizen input? And this particular measure says that citizens should be allowed to go and meet as a charter committee, but there should not be any kind of infringement or abuse of their ability to meet. And I think that was well indicated and set up in the hearings on both sides from the charter committees, that they were running into situations where they weren't allowed to meet, that there were instances where they didn't feel that they could meet, and this allows them to meet.
Thank you, Senator. Thank you, Chair.
Thank you. Assemblyman De Silva.
Thank you, Senator, for your presentation. I just have a two-part question over here. One, I was also really interested in the fact that it seems to be that only North Las Vegas is really being focused on in this legislation. And then secondly, also the fact that we have some civil. I'm trying to read through this. It looks like it may be potentially criminal sort of penalties placed on any sort of violation pertaining to abuses of power. My question is, why is it only focused on North Las Vegas, and what about some of the other municipalities too that could be benefited by language like this?
Thank you for the question, because that was the only issue that was brought up during this legislative session where there was a complaint that the charter committee was not allowed to meet. Based on the testimony and the fact that I've been in this building for a really, really long time, there have been no other charter committees that came to the legislature saying that they didn't have the capacity to meet and that somehow the law was being violated from the charter. I've never heard that story from Reno or any other jurisdiction that's been here that has said that they have not had the ability to meet as a charter committee. The charter committee has actually been a respected entity that is brought forward and is allowed as citizens to bring forward issues and have a discussion about them.
Members, any additional follow-ups, Assemblyman? No? Okay. Assemblyman Koenig.
Thank you, Madam Chair, and thank you for presenting this today. As I was reading this in my sleep-deprived state, something that kind of jumped out at me and then just made me question a little bit was in Section 3.4, we're making a law telling the clerk that they can't break the law. And we're making another law that says don't let the city council or the city managers coerce you to break the law. I mean, does this need to be part of a charter? Don't we have laws and regulations already telling them what they need to do? And do we need another law say don't break the law?
Thank you for that question. It also says to take an oath of office. This particular provision, and there are a series of incidents that have occurred, I believe, at the city of North Las Vegas, where basically I'm allowing the city clerk to get a conscience, right? Meaning that you are responsible for what you're responsible for. You should not be influenced by anyone else in regards to what your duties are. And I know an instance where directly related to where I felt the clerk may not have done or followed the actual law. And I brought it up as a complaint. And I continue to bring it up as a complaint. And in this case, I'm just protecting the clerk to basically say, yeah, do the law. It's interesting because there was actually an assembly bill that moved from this house to the other house that basically said, follow the law. And we thought it was interesting that we were putting in statute, do the law. And that's all that's doing. There would be no issue if there's if there's legitimate behavior going on. This is a null provision.
Thank you for that response. I just don't have the history and know, what happened in the past. I just read that and thought, So, thank you.
Thank you. Assemblyman Nguyen.
Thank you, Madam Chair. Good morning, Senator. In referring to the past experience of the other bill that we heard previously, looking at this section right here in terms of ensuring that they have the capacity or the training to do this, are you concerned with setting some more guidelines in here, guardrail if you will, if they have the comprehension to do this? Because it felt like to me from that learning from the last time was that a lot of the committee members were not trained. They didn't really know what was going on. There was a lot of conversation around, well, I didn't know if I'm supposed to do that. I don't know if I can do that. Are there training or steps in place or even a tether to an actual ex officio role, whether it's a city manager designee or some sort of department designee that could really be their go-to for this? Because if you only meet every 2 years, your knowledge of how everything works is go in one ear, go out the other, because you have lives and you have other things to do. And if this committee is so significant to it, I feel like the members themselves don't have either the protocol knowledge or the know-how knowledge to be able to execute something like this. And if this is going in to ensure that they can do this, right, how can we ensure that they have the knowledge to be able to execute their job?
Thank you for that question. So first off, I'm going to deal with the timing first, and then I'm going to deal with the other part of your question. It's going to allow them to meet quarterly. I do think that there was a training issue. I also think that, regular citizens who get appointed, right? So, the legislature is allowed to appoint. I was allowed to appoint someone to the charter committee, and so were a couple of other members allowed to appoint. And I appointed an attorney, right, to the charter. She also testified, right, that to the issues in regards to this particular charter committee being able to meet. She was a Latina who I appointed to the charter committee. And from my understanding, most of the people are very astute. But I would not be opposed to some kind of training piece because, I don't know if you guys heard from Donna Darden. I know she sent letters. I believe it was Romero, who was an ACLU attorney. There was an older Caucasian gentleman who testified. And I think the right people are on. What they thought charter committees do, I don't think they felt they were able to do, which was the simple act of meeting, discussing, and then having a conversation and then presenting those issues, right? So the council would then present to them. And I think that training is okay, but not qualifications, right? Because if it's supposed to actually be public voice in a regular resident, you can't, in the rawness of what a resident has to offer, right, for being a citizen, they should be allowed to present that in the way that they understand government. And one thing that I think is super clear is that diversity of thought that comes from varying ranges of position, status, is valued, right? Because if you have a person who is coming from poverty, not an attorney, right? What value do they bring in order to enlarge the conversation, because they're having very different experiences within that actual city environment. But I wouldn't be opposed to some training. I just don't know who would administer it, right? I think it would have to be a partner city who has had a charter for a longer period of time, because this charter is fairly new. And I think that's why there's a lot of hiccups, right? And if you were to read the record when this was brought forward, they weren't necessarily in support of having a charter. It was then through the chair at the time, Senator Flores on the other side, where it was brought forward because they were bringing forward the issues without a charter, right? So then this was to reverse it. And so I think we need to put that into context, that the reason why the charter language even came into existence, because they had brought forth issues as a city. And the conversation was, have you talked to your residents? And why hasn't this run through a charter committee? Then a charter committee was created. And now that the charter committee is created, now we're running into an issue of the independence of the charter committee as residents to think through issues and meet. Why does that exist, right? So I think it's very important to look at that trajectory on how we got here and why that charter committee is in place and why I'm seeking to give some independence and attempt to protect it. Do I think that this goes pretty far? Yeah. And there's some pieces that I would take out. However, the reason why I didn't take it out on the Senate side is because my own city was attacking me in the paper. And they were directly attacking me in the paper. And so my thing was, if you're going to abuse your power to come for me, then what are you doing for regular citizens? And that was crystal clear that it was an abuse. And so my thing was, all right, the criminal piece is probably going too far. But civil penalty, I don't think so.
Quick follow-up, Chair. Thank you for going there, because I think it's necessary for us to be able to look at if there are city official who ties to this. For example, when I sat on the Planning Commission, we had the DA assigning an attorney to staff the Planning Commission, and we had briefing right before we go into the meeting. I think that those briefings should have been done days earlier, so we had time in between. But anyway, that was how it's done. That there may be a legal support to this charter committee that should be in there. I don't see it in there, where they can go to that maybe perhaps it's a city attorney, so that they know what step to take, and perhaps that training should be there in the form of the briefing before the actual agenda take place, so that you can refresh the memory. Because if you only meet so infrequent and the everyday people, I mean, look at us as legislator, we have to go through the entire academy for us to get here, right? And not everything was retained. So for something that it's going to only meet so infrequently, that they have such a large undertaking, that I feel like the infrastructure needs to be set up better so that we're not setting them up to fail.
Senator Neal, for the record, I actually like that. The briefing beforehand, I don't know if the city attorney is the person who would be appropriate to do that, but there should be some person who is potentially doing that. I agree with not setting them up for failure. I also am not opposed to striking out my in addition to a criminal action. But the reason why I didn't, and I said it already, I didn't take it out is because literally I feel very strongly about the abuse of power piece.
Thank you, Senator. Thank you, Chair.
Assemblywoman Thomas.
Thank you, Madam Chair, and thank you, Senator, for being here today. And as a resident of North Las Vegas, and a citizen of the United States, when I see a good bill like this, meaning the first half of your bill, that we're talking about things like workforce development for people that have been deprived of certain inalienable rights. And then we haven't talked about this much in this discussion. We go back to the city of North Las Vegas, where I believe there is this thing called implicit bias that's happening here. Let me finish. When I see the city that I live in, that my children live in, that my grandchildren live in, my friends, and I look at this codicil to a good bill that you've placed in here, I'm ashamed. And the reason why I'm ashamed is because of that implicit bias. It reeks with retaliation. Yes, ma'am, it does. And, let's get started. Since we got to go here, let's go. I'm ready to go. Thank you. And because, when we say things
All right,
like...
Assemblin Thomas, if we could just get to the question. Thank you.
When we say things like the city clerk, who I know personally, that I worked with for over 20 years, this besmirched her, just like you feel when you just finished saying that the city did to you, you're doing to her. She is a black woman.
Assemblin Thomas, if we could get right to the question or the concern with the bill.
My
Thank you.
concern with the bill is section 3.2, 3.4, 3.6, and 3.8. That's my concern.
Thank you, Assemblywoman Thomas, for those comments. However, and I appreciate your perspective on this, I have also lived there my entire life. I was born and raised in the city of North Las Vegas. I have children who went to school there. I don't have any grandchildren. However, I also have friends that live there. This particular provision is set up to provide independence for the Charter Committee, point blank. That part on the Charter Committee and allowing them to meet quarterly. The piece on the clerk was brought up because I feel like if you're not going to properly notice, allow the individuals to, open the space, open the building, and allow them to meet, basically it says follow the law. Now, there were instances, and I'm sure that, every time I say something, I'm sure that, there will be a counter, but I directly complained about the election process and that if they didn't follow the Secretary of State policy or law. I also presented and showed that there was a financial disclosure filing that did not occur prior to the appointment or prior to the filing. It fell on deaf ears. It was very clear what the statute said, and it wasn't followed. And then I was told, well, the clerk said that, I could not do it this way, but the law had prescribed one way to do it. So that particular sentence in there around elections and abuse of public trust, the idea here is to give this person a conscience, not to say that they are somehow doing this act, but to also make sure that they are acting independently. I also said in this testimony that in addition to any criminal action, I was willing to take that piece out because that did go too far. But I moved this not because I am retaliating against the city. Every conversation in the hearing was that you should allow the Charter Committee to meet. The questions in this committee were you should allow the Charter Committee to meet. I don't have any of those other provisions in the other part of the bill. And we want to talk about retaliation. There has been serious retaliation, period. there have been series of the charter committee folks coming and saying and writing letters to this body about what was going on. And I don't think that they were not saying the truth, because they continued to say it from one house to the next house in the exact same form.
Yes, if it pertains to the bill, yes. Go ahead.
It does. You know, when we say things like the charter committee didn't have the opportunity, we in this committee sat there and we watched the video. And over and over and over again, the committee had an opportunity. Now, when you stated something about people that were appointed to the charter committee, I also appointed a person who is a regular citizen, you know, no ties to an election, no ties to the candidate that brought forth SB 184. And, you know, you mentioned Donna Darden, who actually worked on that other campaign. When you look, yes, you did. And when you look at other people that have implicit bias, I think that when I say retaliation, it's there. And that's the question that I have.
Okay.
You know?
So, Assemblywoman Thomas, we can agree to disagree. Me bringing up Donna Darden has nothing to do with the campaign. Donna Darden has been in the community well before that race. Donna Darden has actually been an upstanding person who never had anything different to say. She's actually just been a person who's set apart to try to do the right thing. None of that, none of her responses were built upon the fact that she was associated with the senator in the other house. Nor am I bringing this bill because of that campaign. So if you ride that train in this committee on the fact that I am somehow bringing legislation for a campaign that was lost.
I'm going to go ahead and cut us off right now.
You
because
need to,
I don't think that
because
it's fair
that's
for
not
us to
appropriate.
I'm going to cut us.
That's not appropriate for you to do the things that you're doing right now.
Assemblywoman Thomas, I have asked us to stop. At this time, it is not acceptable for us to get a piece of legislation and to challenge the intentions of our colleagues. That is not acceptable. That is actually a part of our rules, that it is not acceptable. And I will not allow us to if we want to ask questions about the policy of a bill, we can ask questions about the policy of the bill. But we will not attack our colleagues and their intentions. I believe that, you know, I truly do believe that when we bring legislation, and I believe this is all of my colleagues, regardless of their political party, that we bring it with the intention to better our community and to better our state. And I too believe that of Senator Neal's policies and the policies that she brings before our committee. And I think that it is unfair for us to challenge those, especially for someone like Senator Neal, who I've had the privilege of serving with and who has done so much for our state and so much for our community. And it is unacceptable for us to challenge that. If we want to discuss the policy, we can discuss the policy here today. That's what we're here to do. At this time, are there any additional questions regarding the piece of legislation before us? I do not believe there are any. Thank you so much, Senator Neal. Thank you for being with us today. At this time, I'll go ahead and move on to support for SB 246.
Hello, my name is Jovan Jackson. I'm a citizen of North Las Vegas, and I support this bill. You know, the city charter should be able to meet with the city council. I think it's as simple as that. They should be able to convene. Once you take all the emotions out of it and all the politics, they should be able to meet with the city about issues that are going on in the community. If the city charter is not able to meet, you silence many North Las Vegas citizens. It's as simple as that. I don't think it gets any simpler than that. So I support this bill. I hope you do too. Thank you.
Is there anybody else here in Carson City? I don't believe there's anybody else here in Carson City in support for SB 246. I don't see anyone in Las Vegas. BPS, is there anyone on the line wishing to testify in support of SB 246?
Callers, if you would like to testify in support of SB 246, please press *9 now to take your place in the queue. One moment, Chair.
Good morning. morning, Chair and members of the committee. This is Catherine Nielsen again from the Developmental Disabilities Council. I'm going to be short. Working age people with developmental and other disabilities are among the most unemployed and underemployed segments of our society. And too often, unemployment and poverty are often accepted as an inevitable result of living with a significant developmental disability. Employment is an avenue to independence and increased socialization for all, and particularly those with developmental disabilities. We support this measure and thank the bill sponsor for her hard work.
Good morning, Madam Chair and the committee. This is Dara Martinez representing the Nevada Disability Peer Action Coalition. I would like to echo the comment of Catherine Nielsen, and big shout out to Senator Neal. We appreciate you and thank you for acting like your age and not your shoe size. Take care. Have a good day.
Chair, there are no more callers choosing to testify at this time.
Thank you. At this time, we'll go ahead and move into opposition for SB 246.
Good morning, Chair Torres, members of the Hardest Work Committee on Government Affairs. For the record, Leonardo Benavides, City of North Las Vegas, here today in opposition to SB 246, especially in regards to the language involving the Charter Committee. While we were neutral previously when SB 246 was in the Senate Government Affairs Committee, that has changed due to the floor amendment, Amendment 486, that added oversight powers to the City of North Las Vegas City Charter Committee, which is meant to be an advisory committee, not an oversight committee. Amendment 486 is also problematic because it targets additional portions of the City of North Las Vegas Charter only, unrelated to the workforce development requirements in the original bill, and like anything you would see in any other city charter. While we understand what the sponsor is trying to do with the workforce development aspect of the bill, we are concerned with the other components of this bill touching our city charter. Similar to concerns we had with SB 184, we are concerned with more changes made to our charter without going through the proper procedure in the interim. Yes, the legislature has the ability to amend a city charter, but generally this is done in a collaborative manner with the city. Any requested changes to a charter for legislative beta go through a city council approval. It is their prerogative as to what the city proposes. And that's an important item to note. The legislature already has final say in what can go in a city's charter, and on top of that, the legislature gets 6 appointees to our charter committee. So why is the additional oversight needed? If the lack of means to concern, why not just change the amount of times a charter committee can meet? Why is now an unelected citizen advisory committee under the city's purview given the charge to report a city manager and the elected officials voted by the community to represent the people? It should also be noted that city charters are to the cities what the Constitution of the state of Nevada is to the state. They are documents that need to be reviewed and revised as time passes, but they do not need to be revised at every legislative session. This is one of several bills this session that has specifically singled out the City of North Las Vegas and straps the city with an unfunded mandate that also looks to significantly impact our city charter without any involvement from the City Council. Collectively, these bills have a significant impact on our general fund and our council's ability to govern. As you all know, the city's general fund is dramatically different than it was a few years ago due to the actions of our policymakers and city team. And these unfunded mandates and policy decisions could place a significant burden on our local policymakers, who have worked hard and made the necessary decisions to move the city in a direction where we can even have this conversation. Thank you. And just want to add quickly, also testifying on behalf of the consortium made up of the cities of Las Vegas, North Las Vegas, Reno, Sparks, and Henderson.
Thank you, Madam Chair and members of the committee. For the record, Stephen Wood, representing the Nevada League of Cities and Municipalities. I will keep it brief and let you know, as we have throughout this session, we stand in solidarity with the City of North Las Vegas and echo the comments that Mr. Benavides just made. We have serious concerns about the provisions of the bill relating to the city charter. Thank you.
Thank you. I don't see anybody here in Carson City wishing to testify in opposition to SB 246. At this time, is there anyone in Las Vegas? I don't believe I see anyone. BPS, is there anyone on the line?
Callers, if you would like to testify in opposition to SB 246, please press star 9 now to take your place in the queue. One moment, Chair.
Hi, my name is John Johnson. For the record, I'm a North Las Vegas resident, as well as I am the community advisor for Councilmember Roan, and I've worked on every one of their campaigns besides the newest appointed councilwoman. I've worked with this city council and the staff since 2012. And I just want to bring up some things because I've been hearing a lot of stuff, and I stayed out of it at the first one, but I can't be quiet anymore. I mean, people are saying that the city is preventing the charter committee from meeting. Let me read you the the city charter. It says, Section 1.110, Charter Committee Officers and Meetings. Section 2 says that they're supposed to meet every 2 years before the beginning of each regular session of the legislature and when requested by the city council or the chair of the committee. My question is, did the chair reach out to the city to request a meeting? Because all he or she has to do is follow open meeting law. They can have a meeting next week if they want to. The NRS is already there independently to allow them to do what they need to do. Nobody is stopping them. We've seen the video. During the meeting, the city was very educational. I understood everything. They even closed an agenda item. The woman had said something. The guy told her, hey, the thing is closed. If you guys want to talk about it, you guys have to put a motion to reopen it, and you guys can talk about it. It was a pause. It was a quiet. Nobody said nothing, so they moved the agenda. So to sit here and keep trying to act like the city is preventing these people from doing their job is a lie, and I'm tired of hearing it. And then when it comes to the city clerk, yes, she's a personal friend of mine too. Yes, she has character. I think this comes from her decision that she did with rent control. I was upset as well.
Thank you, sir. Your time is up.
I don't think it's so rude.
Chair, there are no more callers choosing to testify at this time.
Thank you. At this time, we will go ahead and go to neutral. Is there anyone here in Carson City wishing to testify neutral? I do not see anybody here in Carson City. Is there anyone in Las Vegas wishing to testify neutral? I don't see anyone in Las Vegas. BPS, is there anyone on the line wishing to testify neutral to SB 246?
Callers, if you would like to testify neutral for SB 246, please press star 9 now to take your place in the queue. Chair, there are no callers choosing to testify at this time.
Thank you. At this time, we'll go ahead and invite the senator for any closing remarks.
Thank you, Madam Chair. So this bill simply is trying to create and give independence to the Charter Committee. I'm not dictating what they discuss, which was what was in the other bill. I'm not saying you should take up these issues. I'm saying that you should be allowed to meet. That was testimony that was presented, and if you look at the letters that were sent from the mayor's consortium, they said this should run through the Charter Committee, allow the Charter Committee to meet. Simply, I'm allowing the Charter Committee to meet and giving them the independence to do so. I read all of the opposition, and all of the opposition came down to the Charter Committee should be allowed to meet. I'm allowing the Charter Committee to meet. I also am willing to take the criminal piece out because I felt that it did go too far. Any other commentary related to anything else is outside of the public policy, and that there is no bias. I'm just trying to make sure that the citizens who signed up to be a part of the Charter Committee can meet. And with that, if it's up to the chair, I can provide the amendment that eliminates the criminal piece. But ultimately, the bill does nothing that the other bill did. It just allows the Charter Committee to meet independently, or gives them some independence, not independently.
Thank you. And Senator Neal, I think you did send me a message. I think you had a question that you wanted clarification from legal.
Yeah, so I don't know if Mr. Killian can further break down that I'm not dictating issues that the Charter Committee take up, but I'm actually trying to provide them some independence so that they can meet and then work with the council and on 4 issues that could be brought to them to discuss.
Thank you, Madam Chair. Asher Killian, Committee Counsel. So I believe that's a correct statement that in section 3.2 of the bill that amends Section 1.110 of the North Las Vegas City Charter, there are no particular topics that are required to be discussed, but it does empower the City Council to request not more than 4 items to be considered by the Charter Committee. So the City Council does have the power to request a certain number of topics, but there are no certain topics that are required to be discussed by the committee.
Thank you for the clarification, Mr. Killian. At this time, I don't believe you have any additional remarks. So we will go ahead and close the hearing on SB 246. I will move on to the next item on our agenda, which is public comment. Is there anyone here in Carson City or in Las Vegas wishing to testify in public comment? I don't believe I see anyone. BPS, is there anyone online wishing to testify in public comment?
Callers, if you would like to provide public comment, please press star 9 now to take your place in the queue. Chair, there are no callers choosing to provide public comment at this time.
Thank you. At this time, members, any additional remarks before we adjourn? All right, let's go ahead and adjourn. This meeting is adjourned. I'm sure we will reconvene at some point in the next couple days.